On the slopes of Wisconsin, a legal storm is brewing. A simple job dispute has turned into a major showdown over religious accommodation. Snowy hills, big questions, and a case that's picking up speed. Stick around for our discussion on this topic. Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you're allowing your faith to shape your politics, or are your politics starting to shape your faith? In other words, what do you do when God and government come face to face? I'm your host, Orland Johnson. Let me introduce you to our guest panelists for today. First, we have Dr. Amilcar Groff, Jr., a pastor, an attorney, a professor of philosophy, theology, and law at Washington Adventist University. We also have with us Ms. Melissa Reed, who's the Director of Government Affairs for the North American Division of the Seventh-day Adventist Church. We have Ms. Bettina Krause, who's the editor of Liberty Magazine, and we have Mr. Bob Burrow, who's the General Counsel for the North American Division of the Seventh-day Adventist Church. Ladies and gentlemen, great having you here and looking forward to our conversation today. The EEOC is continuing its scrutiny of religious accommodation in the workplace. Particularly since the pandemic-era vaccination requirements, American employers have faced increasing enforcement actions and litigation regarding religious accommodation requests. Additionally, there's the case that was called Groff that heightened the burden of an employer to show that an accommodation would constitute an undue hardship, clarifying that an employer must show a substantial detriment to its overall business. The Trump administration, through the EEOC, has emphasized its priority of restoring even-handed enforcement of Title VII and ensuring that workers are not forced to choose between their paycheck and their faith. You know, Bettina, when I take a look at what's going on with the EEOC and the aggressiveness now that they're involved in protecting your religious freedom in the workplace, it makes me wonder, is this part of the confusion between the separation of church and state? Or is it just simply the new paradigm of what we're looking at as it relates to work? I'm beginning to wonder, is the government getting a little bit too connected to religion, or just simply something that from a political standpoint, you just can't stay away from? Where's the EEOC on this, and are they moving in the right direction?
Well, Orland, I have to say I'm 100% unapologetically pro-religious accommodation in the workplace. So, my reaction to the EEOC's aggressive focus on this issue is long may it continue. I mean, you mentioned, Orland, the legal history on this. So, for anyone who's followed this, that for almost 50 years, from 1977 to 2023, American employers, they basically got a free pass to ignore employees who came to them and said, hey, is there a way to accommodate my religious practice on the job? So under Title VII, there was a very low legal bar for employers. But then, as you mentioned, Orland, the case of Groff versus DeJoy, 2023, the court essentially said to employers, enough. You've got to take these requests seriously under Title VII, or there's going to be legal consequences. So it tightened the legal standard. So, we're seeing this renaissance on this issue at the EEOC because of this history. That's great news for religious liberty. The agency, I think, has filed 11 religious discrimination cases thus far this year, highest number in nearly a decade.
Wow.
But my heart does sink a little bit because the aggressiveness with which they're tackling this issue, I think, kind of reinforces the narrative that this is a political issue, that it's a left versus right issue. It shouldn't be, but unfortunately, that is a reality that we as religious liberty advocates need to work against.
Orland, I'm going to continue on and fangirl over the EEOC and the role that it plays for employees who have challenges being accommodated for their religious beliefs in the workplace. The Seventh-day Adventist Church has really appreciated their partnership and their efforts on behalf of employees for many, many decades. It's interesting, you mentioned in your opening that a lot of this is coming as a result of the Groff ruling, which Bettina touched on, but then also sort of the COVID religious accommodation request. And it was interesting, I was actually shocked. The number that I saw was 10,000 complaints that have been filed with the EEOC on that particular issue or on that particular area. So I think for sure this is unfortunately, like most everything that we see in Washington, has political implications or undertones. That said, I know that it's going to benefit a lot of people of faith who have not received appropriate accommodation in the past.
Amilcar, I got to ask you, you're probably uniquely positioned because you're probably a pastor that had maybe a parishioner that wanted to get, quote unquote, maybe a letter from the church regarding their, quote unquote, religious beliefs. But on the other hand, you're also an attorney who understands the legal requirements and how far you can go before you end up damaging your position as opposed to really helping. So when you see these type of matters with the EEOC, that kind of balance between the political, but yet we want to be helping from a religious standpoint, where do we go so we don't end up having the rest of society thinking that we're being treated in a special way?
Yeah, that's a great point. And even some places I've heard that workers were told that they could keep their jobs only if they paid a vaccine incentive fee or something like that. So actions like that are really just a fast track to litigation and a lot of money being spent in those situations. So the EEOC's message here seems to be clear. If someone has a sincere religious conviction, meet them where they are. Explore the alternatives and do it in good faith. Find real accommodation. And that's where the workplace culture really matters. Building those good relationships when employers engage with accommodation requests early and openly, they avoid lawsuits. They prevent resentment and they build a healthier atmosphere. And as Christians or from any background, religious background, you're looking for that kind of healthy atmosphere also in your workplace.
Well, Orlin, the practical issue here, and there has been a lot of complaints. There's a big settlement at the big medical school out at the University of Colorado with some plaintiffs, and it goes to the professor's point about paying a fee to, offset whatever if someone had a objection to being vaccinated. The issue is there's some companies that there's a hostility towards people of faith. They're not really interested. They think you live in fantasy land or whatever they want to say. And then there are those who say, you know what, we have to have vaccines for people because they're food handlers or they're medical personnel or whatever. I'm much more sympathetic towards the latter than I am the former, of course, but there are ways to accommodate. And I think we as people of faith have to understand that there are some instances where there really aren't any ways to accommodate. And we have to be willing to accept that. But at the same time, many companies are very ham-handed at this. They just are not really equipped to deal with these type of issues. And they say, well, we need a letter from a church. It doesn't work that way. You can have a sincere religious belief without being affiliated with the denomination.
So, Bettina, this is the question, though, and Amilcar kind of brought it up, and Bob touched on it, a sincere religious belief. The real question is, who gets to determine that bar? Is it your employer? Do you end up having to go to court? You have to demonstrate what you've done prior to this moment, even though we realize your religious points of view can be changing from day to day, but yet somebody's trying to determine, is this sincere enough? And that seems to be really the slippery slope here.
It's fascinating, Orlin, to see some of this litigation that has emerged post-COVID. And you are seeing these multi-million-dollar payouts to employees from employers who have as Bob put it, they've just been ham-fisted in the way they've dealt with this issue of sincerity. They have assumed insincerity. And that is not how you go about these things. It's been fascinating to read accounts of juries in both red and blue states. I mean, this is not just one or the other. They have consistently found that employers are skipping steps, they're assuming insincerity, they're misunderstanding the law. As Bob says, you don't need a clergy letter. But more than that, and this goes to your question about sincerity, Orlin, the courts, the juries are finding that beliefs don't have to be perfectly articulated. And in fact, and this is the interesting bit, they can be mixed with non-religious motivations. Now, that's a shocking thing for some of us. But it goes to the point that when an employer is dealing with an employee who's standing in front of them and asking for an accommodation, they can't make assumptions. And they most certainly have to proceed in good faith. With the assumption that the employee is sincere in his or her belief.
Wow.
And that's the point, right? The law requires a level of reasonableness, but the outcome we want goes beyond mere compliance. It's a workforce where people feel respected and valued. That's just not good ethics or smart legal governance. It's always also good business to have employees that are really engaged.
HR people, management, line management, they see accommodations for disabilities or religion as a pain in the neck, and it's a problem they don't want and they don't need. I won't bore you with my war stories, but I took a deposition one time of a lady, an HR person in a very large company. It was a religious accommodation case, and I asked her about certain questions. I said, well, how do you determine the sincerity of a belief of this particular faith of my client? She said, well, I asked my pastor. I said, well, what denomination is your pastor? It's a totally different denomination. And I'm thinking to myself, that's what's wrong with this. This is just ridiculous. And we prevailed, of course, because this was not a small mom and pop organization. This was a large company with resources. And I'm not suggesting this lady was unprofessional, but this particular thing, they were ill prepared.
Orlin, to Bob's point, one of the things that I appreciate that the EEOC has done with its sort of new prioritization of religious accommodation is provided guidelines for employers, right? Make sure that you have a policy for your organization and make sure that you have a process for an employee to go through a religious accommodation process, and make sure, especially to Bob's point, that your HR department is understanding, right, that they have received training. I think that will go a long way to preventing 10,000 claims against, an employer or things like that. With the Groff case, the standard was changed or returned back to reasonable accommodation. So I think employers should be looking for, they should be appreciative of this additional guidelines.
Melissa, I'm going to let that be the last word, but I think where we're really going is trying to find not only the balance, but making sure that the organizations that have to deal with this have training on both sides of the equation, and religious organizations have to be accommodating to some degree as well, because not all accommodations are going to be possible, and we just have to understand that. Coming up, we're hitting the slopes of Wisconsin. Don't go away. We'll be right back. When faith and government collide, the issues can be complex and consequential. Faith in Politics explores how religious conviction intersects with law, policy, and public life, offering depth, balance, and clarity with meaningful discussion and trusted insight. To see a bunch of our previous episodes, check us out at faithandpolitics.tv and subscribe to us on YouTube. There's a recent case called EEOC versus Crystal Ridge Ski Area LLC, in which Crystal Ridge is doing business as the Rock Snow Park a winter sports park and summer events venue in Franklin, Wisconsin, being accused of violating federal law when it terminated a lift operations manager because of his religion. The EEOC charged in a lawsuit that was announced recently that, according to the suit, Rock Snow Park fired a Christian employee because of his religious beliefs in violation of the law, and the employee frequently posted Bible verses and faith-based messages on his personal social account, and as a result thereof, he was terminated. You know, Amilca, when I take a look at some of these type of cases, first and foremost, trying to draw the distinction between you being engaged in, quote unquote, your First Amendment rights to share what you believe as an individual, even from a religious perspective, but on the other hand, making sure that you're not making a workplace environment uncomfortable for those who don't have similar beliefs. It seems like the EEOC here is trying to figure out how to manage that, but when we look at it from a big picture standpoint, what are the issues here and how can they be managed without much angst taking place?
And maybe where do you draw the line as well, right? What happened at the Rock Snow Park is a great example of misunderstanding about those boundaries of personal expression and the workplace. So this Christian employee posted Bible verses, Bible messages, and his personal media profile. Nothing about the workplace, nothing targeting coworkers. He checked with his supervisor and he was told that it was okay. And 3 days later, he gets fired. That's the kind of decision that draws immediate attention from the EEOC because it really touches on basic workplace fairness. Whatever happened to being reasonable? People bring their identity to their workplace and hopefully not as a weapon or a wedge, but as part of who they really are. And then when private spiritual expression with no workplace connection becomes grounds for termination, something has gone really wrong.
That case is still pending. It's not been resolved yet. It was filed, I think, in the summer. I don't recall exactly, but I've always been an advocate because I've typically represented organizations, SDA and commercial organizations. And I've always told my clients, you can control certain kind of speeches in the workplace or speech. We have a rule around here at North American Division. We're not permitted to use profanity. And the same is true, Professor, at your employer.
Yes.
So there are limits that an employer can put on the issue of what is acceptable speech. We're not a factory. We don't punch a card at 5:30 and then we're gone. We have a certain influence that identifies with our employers after hours, if you will. But there are limits to how far an employer can reach into your private life. The interesting thing too here was the clash of rights, the sort of the hate speech versus the expression of religion. I would be very curious to know what texts were posted and what religious messages were posted, but the complaint stated that the organization was concerned about some variety of hate speech. I suspect that there are organizations that do engage in provocation. Religious organizations, I mean, just to stir the pot, as it were. And there are other situations where people who are opposed to this type of speech raise it as hate speech because they just don't like religion. I'm not sure where this one lies, and it'll be interesting to watch the case. But the issue of extending the reach of the employer to, as Professor, as you stated, a private social media platform where there's no tie to the employer, I don't know how you would connect the dot.
Yeah.
But anyway, that was what struck me about the case.
Well, let me pick up a little bit on what Bob just said, especially regarding there are Bible texts and there are Bible texts in terms of posting them on social media. I wish we could just turn back time and destroy the whole social media metaverse. I mean, that would be my ideal scenario here. But, there are ways of looking at this case, one from a legal perspective, and I think Amilcar and Bob are absolutely right. This crossed the line. One's private speech should not have a bearing on one's employment, barring very extreme circumstances. However, there's another way to look at it, and that is simply as a Christian who's representing the character of God in the public space. And we all have a responsibility when we use whatever platforms that we have available to us to use them in a way that represents our God correctly, and in a way that makes him attractive to those around us. So for individual Christians, the one big issue is police yourself. Be responsible. Be an adult about these things. And remember that social media lives on. It's going to outlast you. So go into it, very, very cautiously.
Orlin, in our last segment, I touched on how I appreciated that the EEOC was providing guidance for religious accommodation in the workplace. And it sounds like this employer could have used that guidance, right? Because as our professor mentioned, there was a conversation between the employee and the employer about what was appropriate, what was happening, is it appropriate, inappropriate? And then 3 days later, the individual loses their job. That doesn't seem consistent with any sort of recommendations that I would think an organization would have in place. So again, I go back to it's always a good idea to have policies in place as an organization before situations occur. I do also want to underline the point that Bettina made as far as we as people who are representing the character of Christ really need to be humble and be deliberate and intentional about what that witness is that we put out into the world. I absolutely think that we have the right as individuals to have that freedom of speech, but I think even more important than the right or the freedom is how we use that freedom.
Actually, Jesus said that there's only one characteristic of the serpent that his followers should have: prudence, wisdom, and how to position themselves. So let's imagine that the postings and the Bible texts were appropriate ones and good ones. This is a case where you see the institution, the organization, overreacting and stepping over some boundaries that should be there in the first place. So this case really reminds us that employees should not be punished just for sharing their faith and their private spaces in the best possible way, obviously, right? Wouldn't it be awesome if we decided to have a society where people can live and speak honestly without fear that their livelihood will simply disappear because someone misinterpreted a Bible verse posted on Instagram?
Well, you don't even have to reach the issue of religion. My father-in-law used to sell Ford. He drove a Chevy. Okay? So should he not be permitted to drive a Chevy because he worked at the Ford dealership selling F-150s and he had a Silverado?
Yeah.
I don't think so. I mean, that puts it on a very commercial day-to-day level that is not deep or wide or really philosophical. And the point is that, yeah, even if this guy was posting texts that, some may consider controversial, as long as it's not tied to the employer. Now, I think they made my father-in-law park his Chevy in the back, right? But I mean, all humor aside, if he wants to drive a Chevy, he can drive a Chevy. If he's selling the Fords, even if he doesn't want the Ford himself, he's doing his job.
Bettina, what really strikes me and makes me most uncomfortable is how easy someone can just fire you. And even if you've got the legal backing for your case, the struggle you're going to have to go through to battle through this, to get your job back, where it seems pretty clear that this is a personal agenda by somebody. And I don't know if you could ever legislate or create anything to control personal agendas. You check with your boss, you say it's good, then one day somebody says you're fired. I'm really stunned as to how easy that process is, and maybe there should be some modification to how easy that process is.
Well, you're right, Orlin. Pursuing a legal remedy in any situation, not just an employment situation, comes with immense cost, both material cost and emotional cost. You don't enter a lawsuit lightly. Talking about the Groff case, I interviewed Gerald Groff for Liberty Magazine last year, and he was telling me the immense toll that case, how much time and effort that took. So, you're right. Our legal system provides an avenue to make injustices, to correct injustices. It's not without a heavy cost for the individual. But I have to say that's why the EEOC's action in this case fills me with a little bit of unholy glee because it's kind of a wake-up call to employers saying, hey, you're not going to get this your own way every single time. Sometimes you're going to get called to account and it's going to be painful, and it's going to teach not just you but other employers a lesson as well.
I completely agree. I am so glad that the EEOC exists, because so many times this is happening to employees who have not budgeted to cover legal fees in case they lose their job, right? These are individuals. I think this gentleman was a manager at this event. He doesn't have the funds to be able to take this on, but it certainly is inappropriate action by his employer, right? And so the fact that the EEOC exists and is able to assist on his behalf is phenomenal, and I'm glad to see that happen.
I'm going to have to let that be the last word, but I also have the unholy glee of the EEOC being involved as well. But the great part of this is that sometimes when one party goes too far, the federal government sometimes actually has a program that can come in and set things straight. And that looks to be what we have here. So we can be pretty comfortable in knowing that every now and then, government does get it right. Amilcar, tell me something I don't know.
Well, in the last program, we talked about Guaraná. So let me go back to my native country of Brazil and tell you about pizza. Pizza in Brazil is so adored, so loved, that São Paulo, the city where I was born, which has this picture behind me, has restaurants that serve all-you-can-eat pizza. And you can even top your pizza with everything from chocolate to chicken hearts. Only in Brazil.
Melissa, tell me something I don't know.
All right, Orlin, we're going back to the ski slopes. Did you know that in the United States, skiing-related accidents happen to approximately 600,000 people every year?
Wow, didn't know that. Bettina, tell me something I don't know.
Okay, Orlin, did you know that in the European town of Bâle, it is built right over a national border, which actually runs through people's houses, so you can eat dinner in Belgium and sleep in the Netherlands without actually leaving your home.
Didn't know that. Bob, tell me something I don't know.
I'm an NHL hockey fan. I played as a boy, and I love the masks that the goaltenders have. But in 1929, a guy named Clint Benedict invented a leather hockey mask. We see all the goaltenders now have them, but there was a day, friends, when they didn't wear masks and were brutally injured. But that's my little trivia piece for you.
Well, thanks a lot. I appreciate that. It's been a great conversation today. And thanks again for you being here with us. Hope you enjoyed our conversation. Just remember, if it's about God and government, it's faith and politics. See you next time.